Hi children, today I am going to start a new lesson, Law and Justice, a Case Study. The title of the lesson is Law and Justice, a Case Study. In our previous chapter, we have learned how laws are made by the Parliament and how they are executed, that is implemented by the executive organ of the government. Now in this lesson, we are going to learn about what happens when these laws are violated by the people, and how can we protect ourselves in case of any violation of such laws. Remember, judiciary is the organ of the government which protects these laws, and now let us see how it does it. Here in this lesson, an example of a property case between Samba and Ravi is given as a case study. Ravi sells a plot to Samba, and Samba pays all the installments of the plot. And when Ravi wants to construct his house in the plot, he notices that the same plot has been sold to Sushil some time ago. And when questioned by Samba, Ravi denies it, and moreover beats him up and breaks his hand also, and also denies to return his money paid for the plot. And in such cases, the first step to be taken is to file a complaint in the police station against Ravi. Now, at the police station, Samba lodged a complaint, and the complaint should contain the following details. It must be addressed to the Station House Officer of the police station, SHO, Station House Officer of the police station, and the details of the complainant must be given there. Date, time and the place of crime, when it occurred, must be given. What happened, the details of the case must be given there, and name of the accused, and gender details and the address of the accused also must be given. Name of the witnesses who were present at the time of the crime, their address also must be given, and a request to punish the accused according to law or section, if we know we can mention it, and signature of the complainant, and address and full details must be given in the complaint. And after this complaint, which contains all these details, is known as First Information Report, FIR. You might have heard this word, FIR. And this complaint, which contains all these details, as we discussed above, it is known as FIR. And the head of the police station is called Station House Officer, SHO. And in some police stations, the SI is the SHO. He himself is the Station House Officer. Now, First Information Report. If we want to make any complaint to the police, it is must to file a FIR first. The first step is to file a FIR at the police station. And after the FIR is filed in the police station, it becomes the duty of the police to investigate and solve the problem. Once we lodge our complaint, that is, if we file our FIR in the police station, then the duty of the police starts with the investigation, and then they solve the problem. And the station house officer will then read out the recorded statement of the person, and then after approval of that statement, the person will sign it. The person who is making a complaint, he has to sign it, and the account of the crime should be entered in the station house register. There will be a register in the police station. In that register, the account of the crime must be entered on the basis of the FIR, and a copy of this FIR is given free of cost to the person who is making a report in the police station. And in case the station house officer of a police station refuses to file the report, the person can go directly to the DSP or magistrate. He can directly go to the magistrate court and file the report. And the report can also be sent by post to them. Now, the role of the police in investigation. One of the important functions of the police is to investigate into the matter, investigate into any complaint made by the people about the crime. And investigation includes recording statements of witnesses. First, the police have to record the statements of the witnesses and they have to collect different kinds of evidences also in the case. And on the basis of the investigation, the police are able to form an opinion. After their investigation is over, they can form an opinion about the accused and what type of crime has been committed by him. And if the police think that the evidence points to the guilt of the accused, if the accused is found guilty, then they file a charge sheet in the court. Only when the police feel that the accused has done a crime, if they are confident that the accused is guilty, then the police files a charge sheet in the court. And it is not the job of the police to punish the accused. It is only the function of the judiciary. Remember, it is only the judges and the judiciary that decides what type of punishment is to be given to the accused. And to decide also whether the person is guilty or not, it is also given to the judiciary and the judges. After they decide, once they decide that the person is guilty, the punishment is also decided by the judiciary, that is court. Now, civil and criminal cases. Civil cases, all the cases which are related to ownership of land, property, income, and people's relationships with each other, all these are called civil cases. And in case of criminal disputes, in case of criminal cases, people are often punished with a jail term. Either they are given imprisonment, whereas in civil cases, they may not be sent to jail. In criminal cases, most oftenly they are sent to jail. And in civil cases, they may not be sent to jail. A criminal case is always handled by the police and not by the person who suffered from the crime. A criminal case, remember, is always handled by the police only and not by the person. On the other hand, a civil case is always lodged by a person who feels that he has suffered due to cheating or breach of contract or due to violation of laws. If any person suffers, he has to make a complaint in the police station. And the police take charge of the criminal case because it is a violation of law. Always a crime is done whenever a law is violated. Due to violation of laws only, criminal cases arise. The police take charge of the criminal case because it is a violation of law made by the government. And in a civil case, the violation is of an agreement between two people. Whatever they agree upon, they do not stick to it and they violate it. So, because of that, one person suffers and the other one is benefited, of course temporarily, but that is called as civil case. Now look at the following table to understand some of the significant differences between criminal and civil laws. Criminal law, it deals with conduct or act that the law defines as offense. If anything, any action is defined as a crime by the law, such cases are dealt with in the criminal law. And for example, theft, taking dowry, murder, all these are offenses according to the law. So, the criminal law always deals with such cases, theft, taking dowry, murder, etc. And civil law, on the other hand, deals with any harm caused to a party due to breach of agreement by another individual. If an agreement is made between two people and if it is violated, then one of the party will be at loss. And then, for example, rent, purchase of goods, divorce, all these cases come under civil law. Cases like theft, taking dowry, murder, etc., they come under criminal law. And rent, purchase of goods, divorce, etc., they come under civil law. And criminal law, usually it begins with lodging of an FIR. In a criminal case, always it should be started with lodging of an FIR and police investigation. After filing FIR, police starts its investigation and then the case is filed in the court. And civil case, a petition has to be filed before the court by the person who has been offended, who is at loss, who has been harmed. He has to file a case in the court. And for example, in a rent dispute, either the owner or the tenant, they have to file a case in the court. And if found, in criminal laws, if found guilty, accused can be sent to jail and also fined. A penalty can be imposed by the court or the accused can be sent to the jail also, imprisonment also. And in respect of civil cases, court provides relief to the offended, like a house may be vacated by the tenant or dues get paid. That depends on the case. Whoever is at loss, that loss will be compensated by the court by giving some alternative, by making some alternative arrangements. If the tenants are causing any problem to the house owners, then the house will be got vacated by the court. And if the house owner is causing any harassment to the tenants also, in that case also the problem will be solved by the court by getting the house vacated or by getting the dues paid. Now here in this table, fill in the table given below based on what you have understood about criminal and civil laws. Now just now we have discussed what are criminal cases and what are civil cases. And here in these two columns you have to complete the columns by following the lesson. It is given as homework. Please do it. In the textbook itself you can do it. The next one is bail. It is the right of the accused. Bail is granted to the accused based on the severity of the crime, possibility of threat to the witnesses, threat to complainant, etc. Based on these factors like severity of the crime, possibility of threat to the witnesses, and threat to complainant, bail is granted based on these factors. And if it is a crime where bail can be granted, only SHO can grant bail. Station house officer only can grant the bail. And in case of non-bailable offences, if the crime is non-bailable, the accused has to move bail petition before the appropriate court. That means the station house officer cannot grant bail. In non-bailable offences, the accused has to move bail petition before the appropriate court. Now in our example, Ravi's case is a criminal case. And after Ravi was charge sheeted by the police, he was put in lockup. And in criminal cases, an accused is kept in jail. But of course, it is not a punishment. This is only to help the investigation as well as prevent him or her from tampering with any evidence or threatening the witnesses. If they are left free outside, they may tamper the evidences or they may threaten the witnesses also. And after some days in judicial custody, they are brought to the court again. A person who is accused of serious crimes like murder, bribery, dacoity, etc., he may not get a bail. To get bail, certain sureties are to be given in the court. For such cases, to get bail, certain sureties are to be given in the court. And these sureties can be property or a person who will stand as a guarantee or bond. The bond is just a promise that offender will appear before the court whenever asked for. And the judge in the court can decide whether to give bail or refuse it. Now the role of the public prosecutor. A criminal offence is registered as a public wrong. Always a criminal case, whenever it is a criminal case, it is registered as a public wrong. That means the crime is committed not only against the victims but against the society as a whole. That is to say that a criminal case is registered as a public wrong. That means the crime is committed not only against the victims but against the society as a whole. And in court, it is the public prosecutor who represents the interests of the state. And the role of the prosecutor begins after the police has conducted the investigation and filed the charge sheet in the court. The prosecutor has no role to play in the investigation. He does not have any role in investigation, and after investigation is over by the police, the role of the prosecutor starts. He or she must conduct the prosecution on behalf of the state. He conducts the prosecution on behalf of the state, and as an officer of the court, it is his or her duty to act impartially. Without any impartiality, the prosecutor has to give his judgment and present the full and material facts. Whatever are the material facts of the case, they must be presented by him, even the witnesses and evidence before the court, to enable the court to decide the case. All these material facts, witnesses and evidences which are collected, they are to be presented before the court by the prosecutor so that the court can move further to decide the case. Now, fair trial. Now, in our example, Ravi had to engage his own lawyer, whereas Samba will get a public prosecutor or government lawyer. Now, let us see what is fair trial. The rule of law exists in India. Already we have discussed about it in many times. Many times we have discussed about it. Rule of law means equality of all the people before law. All people are equal before law. Same laws apply to all the people. That is called as rule of law. And the rule of law says that everyone is equal before law. And before deciding if someone is guilty, she or he will be allowed to a fair and impartial public hearing. The person who is accused, he will be allowed to a fair and impartial public hearing. Whatever he says will be listened to by the court people. And criminal prosecution starts with presumption of innocence and the guilt must be proved beyond reasonable doubt. Not because the charge sheet says like that or the FIR says like that, the guilty is accused of the guilt. It is only after it is proved beyond reasonable doubt, then only the accused will be accused of his crime. And in our example, the judge did not come to a conclusion that Ravi was criminal just because Samba was injured. It is to be proved that the injuries were made by Ravi, that the injuries were caused by Ravi. It must be proved, then only he can be accused of the crime. Now the first hearing. The SI, who is the station house officer, he gives a copy of the FIR and the police report to the lawyer of the accused so that he can know the exact charges leveled against the accused and also the evidence collected by the police. And this enables him to prepare a defense for his party, who is the accused. And after getting a copy of the FIR and the police report, then the lawyer, the defense lawyer, he can prepare a defense for his party, who is the accused. And if in the first hearing the accused does not accept the charges leveled against him, the court orders for a second hearing after some days. In the first hearing, if the accused does not accept the charges leveled against him, the court orders for a second hearing after some days. And in our example also, Ravi did not accept the charges leveled against him that he caused severe injuries to Samba. He did not accept it. So, the court ordered for a second hearing after 15 days. And what is the role of the judge? The judge is just like an umpire. You might have seen a cricket. And the judge he acts just like an umpire in a game and conducts the trial impartially and in an open court. In the presence of all the people, he conducts the trial impartially. And the judge hears all the witnesses and any other evidence presented to him by the prosecution and the defense. Both the prosecution and the defense also can present their evidences, and the judge hears to all these witnesses and the evidences presented to him. And the judge decides whether the accused person is guilty or innocent on the basis of the evidence presented and in accordance with the law. According to the law and also on the basis of the evidence presented to him, he decides whether the person is guilty or not. And if the accused is convicted, if he is found guilty, then the judge pronounces the sentence. He gives the judgment. Depending on what the law prescribes, according to the law only the punishment is given to the accused. The judge may send the person to jail or impose a fine or both also sometimes, depending on the severity of the crime. But everything must be according to the law only. Now, separation of powers and independence. As you know, powers are separated between the legislature, executive and judiciary. Hence, judiciary is separate and independent from the legislature and executive. Judiciary, which is the third organ, it is separate and independent of the legislature and executive. The legislature and executive cannot interfere in the functioning of the judiciary. Remember, we have independent judiciary in India. That means the courts are not under the government and do not function on behalf of the government. Courts function independent of the legislature and the executive. Even the Police is also not part of the executive. At district level, like the district collector, there is also a government police officer who is responsible for maintaining law and order within the district. And police department is under the Ministry of Home of the state government. Now, how judiciary is independent in India? Just now I told you we have independent judiciary in India. How can we say that there is independent judiciary in India? And what are the factors that make it clear that it is independent judiciary? First of all, Chief Justice and judges of the High Court and the Supreme Court, they need very high qualifications. Judges in any court, they need high qualifications to be appointed as judges, and also very high experience they need. 7 years, 10 years experience they need to be appointed as judges. And secondly, they are appointed by the President. Judges and Chief Justice of the Supreme Court and High Court also, they are appointed by the President, but they cannot be removed by the President. And a difficult procedure called impeachment is followed to remove the judges, and this impeachment requires the approval of 2/3 majority of both houses of the Parliament. Unless the charges are approved by 2/3 majority of both houses of the Parliament, that is Lok Sabha and Rajya Sabha also, the judge cannot be impeached. And thirdly, salaries of the Chief Justice and the judges, they can be increased by the Parliament, but they cannot be decreased. And due to these above factors, we can say that independent judiciary exists in India. Now, the evidence of witnesses. Both the parties involved in the case give names of some friends as their witnesses. Those who were present at the scene of the crime or any other witnesses, they give their names and addresses of their friends as their witnesses, and all these witnesses receive summons from the court to be present for the second hearing of the case on the given date. A date is fixed, and on that date, all these witnesses, they receive summons to attend the court. The public prosecutor and the lawyer cross-examine the witnesses by asking many questions, and the evidences of the witnesses are recorded. Having listened to all the evidences of the witnesses, after 3 or 4 hearings, the final judgment is given by the court. I am repeating it once again. Both the parties involved in the case give names of some friends as their witnesses, and all these witnesses, they receive summons are sent by the court. Summon is an order sent by the court to come and attend the court. All these witnesses, they receive summons from the court to be present for the second hearing of the case on any given date. And the public prosecutor and the lawyer cross-examine the witnesses by asking many questions. And the evidences of the witnesses are recorded. And having listened to all the evidences of the witnesses, after 3 or 4 hearings, the final judgment is given by the court. The next one is appellate system. Appellate system is, in our country, this appellate system exists. That means if a party is not satisfied with the judgment given by a lower court, he can appeal to the next higher court. Like that, if he is filing his case in a lower court, he can go to the next higher court, next higher court, next higher court. Like that, up to Supreme Court he can apply. He can appeal to the Supreme Court also. If he is not satisfied with the judgment given by the High Court, he can appeal to the Supreme Court. And the Supreme Court can entertain such appeals. And Supreme Court may give the same judgment which is given by the lower court, or it may change the judgment also. So, it depends on the case and how the Supreme Court studies the case. So, up to Supreme Court, a party can appeal for judgment. So, that is called as appellate system. Now, let us see this appellate system in India. There are three different levels of courts in the country, and there are several other courts at the lower level. The courts that most people interact, people most oftenly go to subordinate or district courts. If it is a civil case, they go to the district civil courts, and if it is a criminal case, people go to the sessions courts. And among the sessions courts, there are first class, second class and third class magistrate courts. And usually at the district or divisional level or in towns, they hear many kinds of cases, and each state has a high court. In each state there is a high court and there is chief justice and other judges also, and at the top, at the apex, there is Supreme Court in the country, and it is located in New Delhi. And the present Chief Justice of our Supreme Court is S.A. Bobde. The present Chief Justice of our Supreme Court is S.A. Bobde, and the present Chief Justice of our AP High Court, Andhra Pradesh High Court, is Jitendra Kumar Maheshwari. Jitendra Kumar Maheshwari. Please note down it. Now let us see the different levels in this picture. You can see at the top, at the apex, it is Supreme Court, and below Supreme Court there are high courts at state level. In all the states we have high courts, and after high courts, low level courts. District court at district level, for civil cases it is district civil court, and for criminal cases it is sessions court. At district level we have civil courts, and criminal courts are called sessions courts. And below them there are junior civil judge for civil cases at divisional level, and for criminal cases at divisional level, assistant sessions judge, judicial magistrate. I told you first class, second class and third class magistrate courts are there. Those are at divisional level. So this is the appellate system in India, which is existing in India. What is it called as? Appellate system. Now, appeal at the sessions court, high court and Supreme Court. If the party is not satisfied with the judgment given by a lower court, he or she can appeal to the next higher court. They cannot directly go to the High Court or Supreme Court. If they are filing a case in the district court, then next higher court they have to appeal. If they are not satisfied with the judgment of the district court, they can go to the next higher court. And if they are not satisfied with the judgment of that court also, they can go to the next higher court. Like that, step by step, they have to appeal. So, if the party is not satisfied with the judgment given by a lower court, he or she can appeal to the next higher court. And if the judgment is given by a magistrate court and the party is not satisfied with the judgment, it can be challenged in the next higher court, that is sessions court. For criminal cases, it is sessions court, and for civil cases, it is civil court. So, in case the party is not satisfied by the judgment of the sessions court also, he or she can appeal to the high court, which is the next higher court. And then, even in the Supreme Court, it can be challenged. And the judgment of the Supreme Court is final. As it is the apex court in the country, the judgment of the Supreme Court is final. That is the end of the lesson. And as usual, I am giving you homework. Read full lesson, underlining all the key points, and complete the blanks in the material. And complete the project in page number 183 of your textbook, matching the roles with the functions given. On one side, the roles of the people are given, and on one side, the functions they perform, it is given. You have to match the roles with the functions given.